Hello, my name is Mike Tesaro and I prepared this particular video entitled ACCC Cheat Sheet for July 2024, and you probably noticed down the bottom there it's actually dated 28th of October 2024, which indicates I've fallen behind again. So hopefully I'll be able to catch up over the next few weeks and be back issuing these things shortly after the month ends. Bit of background about myself: I'm a competition and consumer lawyer and I've been running my own practice, Tesaro Legal Consulting, for the last 18 years or so. And I help companies and individuals with competition and consumer law matters. I also do quite a bit of consultancy work on competition and consumer issues for various legal publishers such as CCH and LexisNexis. Also a part-time general member of the New South Wales NCAT in the commercial and consumer division, so I do a bit of actual consumer law on a day-to-day basis through that role. Prior to that, I worked at the ACCC for about 15 years in a variety of different roles, including in mergers and enforcement. Now, the outline to the presentation is fairly straightforward. A couple of court cases, some enforcement action, a couple of mergers, quite a lot of activity out of the National Anti-Scam Centre in relation to scams, some law reform, which is the merger changes that have been embraced by government. Also, the ACCC issued some sustainability collaboration guidelines for comment, some inquiries and consultation work, authorisations, and one other matter. Now, the first case involved Gray's e-commerce group, and it was sort of a strange case because effectively what happened was Gray's was advertising various motor vehicles on its site, and the allegation was it made false and misleading representations about the descriptions of the cars on their site. And it appears there were hundreds of different cars listed for sale over the course of roughly 2 years, where Gray's misdescribed a number of vehicles, and they weren't sort of small misdescriptions. As you can see there, they're talking about the wrong make, the wrong model, features, undisclosed obvious faults with the car, wrong manufacturing year or transmission system, so you think you're buying an auto and you get a manual, listing features that the car listed for sale did not have, and a failure to mention obvious problems. So the ACCC formed the views of very serious conduct, and I guess it must have been a breakdown in their systems for double checking the details about the cars. And the ACCC estimated that it actually had cost Australian consumers approximately $4 million worth of losses. And as part of a settlement which was approved by the court, they agreed to compensate those consumers who had bought cars based on descriptions that was false, and also agreed to pay $10 million penalty. So that was, I guess, a fairly strange one where Gray's e-commerce made a lot of mistakes in a short period of time, but has given redress and paid a big penalty, and so the matter's resolved now. The next case was actually the penalty judgment in this Master Wealth Control and Dominique Grubisa case, which was decided early in the year, and it went for a penalty hearing, and the judge in this particular case issued fairly large penalties, $5 million in pecuniary penalties for making a variety of false and misleading representations about particular education programs called the Real Estate Rescue, RER, and the Master Wealth Control Program. This is all very strange stuff where the company and the owner made representations of making particular property sales judgment proof they couldn't be attacked through the courts, reference to this Vesti Trust. So there's actually a lot of misrepresentations about the legal effect of a particular structure, as well as the decision in a particular case. And as you can see, not only was there $5 million in pecuniary penalties, but also $14.7 million ordered of consumer redress to the students enrolled in this particular program. And the sole director of the company, and she is legally qualified, Dominique Grubisa, was also ordered to pay $1 million in penalties, which is quite a big penalty for individuals, and was also disqualified for managing corporations for 5 years. And the interesting thing here is, subsequent to the penalty judgment, there was some suggestion that she was continuing on a merry way, making misrepresentations. She sought to have the penalty amount stayed. I think she was unsuccessful in that. So a lot more to happen in this particular case going forward. And as you can see, the interesting thing is the ACCC sought redress orders for 2,000 odd students who entered the program. That's been unusual for the ACCC. They often leave the pursuit of compensation or damages to the class action firms, but in this particular case, they've decided to pursue that. The first enforcement action was a voluntary undertaking by Telstra and Optus, and it was pretty big issues involved. Effectively, both Telstra and Optus entered into deals with Google, but as it says there in the first paragraph, Google initiated these particular deals whereby Google would pay these two telecommunications companies large amounts of money to pre-install their search services on Android devices which are supplied by Telstra and Optus. So it effectively buying the default position on these devices, which obviously makes it much more difficult for competing search engines to get onto these particular devices. And Telstra and Optus undertook to basically cancel these agreements after 30th of June 2024 and not to enter into any new agreements with Google to provide them with exclusivity. And this undertaking resolved the concerns which the ACCC had about the conduct. The strange thing here is this is probably a breach of Section 47 of the Act, 45 of the Act, take your pick. And everybody seems to have walked away without being punished with a pecuniary penalty. So I find that a bit strange. I guess the main problem the ACCC was looking at was to get them freed up, get these devices freed up for competing search services as quickly as possible. Obviously, litigating against Telstra and Optus and Google would have taken many years. So I think maybe the ACCC took a fairly pragmatic approach in this particular matter. Next one is Good Guys litigation, and this is on the 11th of July. ACCC took proceedings against Good Guys, which is actually owned by JB Hi-Fi. I didn't know that until I read the press release. And it's alleged false and misleading representations about the store credit and store cash promotions. And effectively, it was a fairly, involved breach. ACCC claimed that Good Guys ran this promotion between a 4-year period where it's offering consumers a store credit or store cash if they spend a certain amount of money on qualifying products. Now, the key thing here is that the way it was represented, as alleged by the ACCC, was consumers only had to buy those qualifying products to be eligible for the store credit or store cash. However, the ACCC has claimed that there was actually some other requirements, namely that the consumer opt in to receive marketing communications from the Good Guys, and that wasn't disclosed. And the other alleged breach was that it was represented to consumers that the store credit and store cash would not expire or would only expire after a fairly lengthy period of time. But the reality, as alleged by the ACCC, is that it expired within 7 to 10 days. So that'll be an interesting case to see whether Good Guys fights it. I don't think it'd be very sensible to fight a historical case along those lines. I think it's probably best just to try and settle it. And I wouldn't be surprised if they're just arguing about a penalty at the moment. The next one was Udi, I think it's pronounced, is owned by a company called Davey Clothing Proprietary Limited, and they were selling this popular loungewear brand, basically for children, that failed to comply with the mandatory product safety standard, and they got hit with 6 infringement notices, a total of $101,000 and $101 and $280, and basically failed to include high-fi danger warning labels on 6 different styles of kids' beach Udis, which maybe it's Udi, I don't know. But anyway, that breached the relevant safety standard. And they sold quite a lot, 2,500 roughly of these hooded towel garments were sold over a period of less than a year. And I think it's probably because the company was small that it didn't get taken to court. This is a very serious breach. A lot of products were sold, so the ACCC has decided not to take them to court. And in addition to paying the penalty, they agreed to establish a compliance program, which they definitely need, and also to publish a corrective notice on their website. Now, there's a bit of merger action, and both of them were mergers which the ACCC expressed concerns about. And the first one was Stockland and Superlie that got together to purchase a number of Lendlease assets. And the Lendlease assets were residential master plan community projects. So effectively, Stockland and Superlie were going to buy these 12 projects and include them in their own portfolio. Now, ACCC had a lot of concerns at its proposed acquisition. I think the first thing is that Stockland's closest and largest competitor in the supply of these residential master plan community housing lots in at least 4 of the relevant regions was Lendlease, so that was taking out the direct competitor. It also was concerned that it may increase Stockland's incentive to raise the price, delay the supply, or reduce the quality of housing lots in those regions. And finally, it may increase the risk of anti-competitive coordination by developers in relation to various issues. So there's a lot of concerns, and not to get too far ahead of myself, but I guess ultimately it does get led through with some divestitures. So it was a lot of concerns expressed, but they were ultimately addressed by the merger parties. Horizon's proposed acquisition of Flinders Logistics also raised concerns, and the concerns related to, I guess, the increase in the amount of rail haulage services which Horizon would have, and they were concerned that this increase in these assets would substantially lessen competition in the supply of such services for import and export of containerised bulk minerals in South Australia. It also would bring together Australia's largest rail operator with a key provider of stevedoring and port logistics services. And it all focuses on this berth 29 in South Australia. And as you can see, it refers to berth 29 as a critical berth at Port Adelaide for the import and export of certain mining products and mineral sands. So basically, owning that will have a very big impact on the ability to export products out of that market. And the ACCC was concerned that this acquisition may provide Horizon with the ability and incentive to limit access to competing rail haulage providers. So this is the only berth that can actually accommodate these particular types of products, and accordingly it'd give Horizon, if they owned it, a lot of power. And also they were concerned not only about the rail haulage side of it, but also the stevedoring services for bulk commodities at berth 29, so it may substantially lessen competition. And as far as I'm aware, I don't think this matter's been resolved, so maybe it's going to be a straight out opposition by the ACCC. Then you move to the scams, and there's been a lot of activity in the scam area, and this is the product of the National Anti-Scam Centre, which is set up about a year ago, and it's done really, really good work with identifying big scams, getting a lot of publicity out there, and I think reducing the level of harm to consumers. This one relates to money recovery scams, which are very problematic because they're effectively taking a second bite from a consumer who's already lost money to try and steal more money off them. So as the Scam Centre identified, between December 23 and May 24, the Scam Watch received 158 reports with losses over $3 million, including losses from the original scam. So they explain how it works. Criminals contact victims, so this is people who've already lost the money, posing as a trusted party, such as a government agency, cybersecurity organisation, fund recovery service, etc. And they use a variety of means to do that. And they tell the victims they recover the funds that they've already lost, most likely to the company that is approaching them. So the company initially steals their money and then comes back and tries to steal more money by pretending to be an agency that can recover the money they lost first time round. So they offer the consumers the service subject to an upfront fee, but furthermore what they seek to do is they seek to get the victim's personal information all over again and seek to steal money out of their various accounts, often trying to get cryptocurrency wallets set up to facilitate payments to the criminals, and then they can remotely access the victim's devices to steal not just financial resources from the victim, but also personal information. And I think the thing here is, it does identify the largest group which are subject to these particular scams. And as you can see, Australians aged over 65 are the largest group reporting damage from this scam. The CrowdStrike scam seems like a long time ago now, but as you may recall, there was a problem with an outage in relation to CrowdStrike Microsoft, and it created a lot of problems. And the criminals are very resourceful and very opportunistic, and they quickly see an opportunity and start calling up consumers and offering the service to fix up any issues arising from this outage for a fee. But they're not actually legitimate provider to these services, and they seek to trick consumers into buying particular software which may register keystrokes, or may just hack into their systems and try to steal money. So I guess the warning there was not to really listen to any unsolicited calls from people offering to help solve this problem. If you want to solve this problem, approach reputable providers of these services yourself. The next one was jobs and employment scams, and this was a decision by the National Anti-Scam Centre to set up a new fusion cell. And a fusion cell is defined as a time-limited task force designed to bring together expertise from government and the private sector to try and really, nip a particular scam in the bud. And here they've set one up for jobs and employment scams. And these are particular scams which try to target various vulnerable consumers to steal their money by offering them very good jobs, very highly remunerated jobs, but they're also seeking to steal their personal information. That's worth a lot of money. They often impersonate legitimate businesses or well-known recruitment agencies. They use a variety of means to gain the attention of the victim, often using social media platforms. And as you can see, a lot of reports. In 2023, over 5,000 reports. Big losses, $24 million, and it's been increasing significantly, 151% increase. In 2024, it's been trending down, which is good, and probably due to the actions of the scam task force, but it's still generating a lot of losses. And I guess not surprisingly, the people being targeted are people with English as second language or non-resident visa holders who are fairly desperate to try and get some work to support themselves. Now, the next big thing in July was the merger reforms, and this is really the ACCC's wish list has been largely agreed to by the government, and the government put it out for consultation. So I guess again, given I'm in October, I know sort of what happens here, but effectively the government is consulting with industry to try and find out what their views about these changes. I think it's fair to say most businesses in Australia don't like these changes. Most big businesses don't like these changes. And it's going to increase the level of accountability for businesses when they're dealing with the ACCC. I think the thing that comes across here is the government is not just bringing these changes through. It seems they're quite genuinely interested in hearing what people are saying, and not to get ahead of myself again, but they do listen to some legitimate concerns about the proposed changes, and they do adjust it. But I guess the thing here is they're talking about a simplified merger control framework. I'm not too sure if it's going to be simplified. I think it's going to be pretty complex, but ultimately it's not about simplification. It's just making sure the system works and doesn't allow anti-competitive mergers through, and doesn't allow gaming and people misleading the regulator about the anti-competitive effects of a merger. So that's really what it's all about, I think. The government will advise separately about, or consult separately about, notification thresholds, which again has already happened. And if you want to see something that's not simple, that's the initial proposal was very complicated, and it's still quite complicated. But I guess it all comes back to this fundamental issue. There's research showing between 1,000 and 1,500 mergers occurring each year. They're not small mergers, and the ACCC is only finding out about 330. So that's suggesting that a lot of people are taking advantage of the voluntary merger regime. It always was based on trust, and unfortunately there's some bad agents out there who are not telling the ACCC about mergers they should. tell them about. One thing I found somewhat surprising is the government's decision to appoint Ms. Gomez de Silva as the advisor to these changes, and I don't know her at all, and I'm sure she's a brilliant individual, but it seems strange to appoint somebody from the UK to advise on a mandatory merger regime, given the UK doesn't have a mandatory merger regime. So it seemed a strange choice. I thought maybe somebody from the US or even in Europe might have made more sense, but to choose one of the three countries in the OECD that don't have a merger regime, a compulsory merger regime seems strange to me. But anyway, I'm sure she'll add a lot of value, but clearly doesn't have a lot of direct experience in mandatory regimes. Then the ACCC issued the Sustainability Collaborations Guideline, and this was put out as a draft guide for comment, and this is probably overdue. A lot of other countries have issued these a while ago. And the big thing is whether companies should be allowed to get together to jointly put forward sustainability ideas that may lessen competition. Are the public benefits in terms of improving environmental outcomes likely to outweigh any competitive detriment, and should these be permitted? And I think when you saw the earlier Brookfield merger or acquisition, the ACCC put a lot of weight on sustainability considerations, but it's much better to have a guideline which spells it all out. And I guess the main thing here is that the sustainability benefits arising from a collaboration have to be well documented and able to be proven. And secondly, it's got to be the only way to achieve the particular sustainability benefits. If there's a way of achieving the same benefits without a collaboration, then it should just leave it to the market. So, as ACCC said, the purpose of the draft guide was to help businesses understand the competition law risks that may arise when contemplating working together to achieve positive environmental outcomes, and also explain how the authorisation process would work in those circumstances. But the thing to be very alert to is there's a lot of cover that people seek to get from environmental collaboration, which is really just an attempt to potentially price fix or restrict access to goods or services. So you just got to be very wary of collaborations. And I guess the Australian system is such that we have a very developed authorisation system. It can take into consideration a wide range of public benefits, probably wider than I think any other organisation around the world. And we actually have signed off on a lot of, authorisations which are promoting environmental benefits, such as product stewardship codes and things like that. There was a bit of action, inquiries and consultations, as there is every month. The first was a water report, and this is about the Murray-Darling Basin. And they issue these annually. They're not super interesting, I don't think. Water availability was high because it's been very wet. Regulated water charges are all over the shop, and that reflects all the different tariff structures and cost recovery approaches taken by each basin state. And there's been a high level of compliance with water rules. I think it's a system that's working pretty well, so that's probably why it's not super exciting. There's not a lot of bad behaviour going on. The gas inquiry report, this is an area where there probably is a bit of bad behaviour going on, but effectively the good news is the East Coast gas market is forecast to have a surplus of between 69 and 110 petajoules in 2025, as long as the Queensland LNG all the Queensland LNG producers export all their uncontracted gas, which is likely. Now, there is a risk of a shortfall in the third quarter, which is obviously in winter, when demand is higher. Gas will also need to be sent from Queensland to the southern jurisdictions to avoid shortfall. So obviously, Queensland's a pretty warm place, but if you're going to be down in the ACT or other areas which get quite cold, gas has got to definitely go down there to assist in local shortfalls not occurring. And finally, and this is probably good news, East Coast gas market prices continue to decline from the highs in mid-2022. So that's also a good outcome. And I think the gas producers are very conscious that if they don't service the Australian market a bit better, there might be some more heavy-duty regulation coming their way. The digital platform, and this is really an issues paper issued by the ACCC to set out the questions that it wants to address in its 10th and final report in its digital platform services inquiry. And so in this particular report, it will be focusing on recent developments in digital platform markets, identifying emerging issues, charting major developments overseas. So a lot of other countries have introduced digital laws very rapidly, and to impact how successful these laws have been overseas. So the issues paper is out, and there's a period of time for people to comment, and then we're looking forward to that final report. The money transfer report was very interesting, and this is a report the ACCC does on international money transfers. And this is a bit of a debacle, really. There was a lot of little players in the market many years ago, and then when the different laws were introduced about money laundering, then I noticed a lot of the banks just closed down a lot of these operators on the basis they said you might be money laundering. And I had some clients who had their effectively their accounts closed down. This is because the small money lenders rely on the bigger banks to provide various services for this international money transfer. And it seemed to me to be the most anti-competitive thing, clearly driven by a desire by the big banks to take over this particular very lucrative market. And I was actually working with some guys in the Himalayan, sorry, not the Nepalese community, and it's hardly noted to be a major sort of terrorist hub, Nepal, and yet due to money laundering concerns and terrorist concerns, most of these small providers had their relevant access closed down by the major banks. But the good news is that the market is turning around, largely due to the activities of fintech providers. So effectively, fintech providers have now come into the market and now providing the big banks with some serious competition, and that's having a positive impact on the market. So you're seeing costs going down when Australians send money overseas, and often they're sending money overseas to support family, or in the case of the Nepalese community, they were sending money overseas to help following various earthquakes in that area. So it was really like aid, and they were all sort of excluded from providing those services. The bad news is that there's a lot more savings to be achieved by consumers, and the ACCC put those savings at about $200 million in potential savings that aren't being realised. The number of IMTs is growing each year, and that's because of fintech business, I said, coming into the market. And also overall transaction costs have decreased over recent years. That's largely due to the ACCC's best practice guidance, which has helped the industry greatly. Authorisations, the first one involved the cash transit, which is a bit of a disaster, really. I think it all comes back with the decision by the ACCC to approve Armaguard's acquisition of their Spanish competitor, Prosegur, I think they're called. And there was a lot of funny business with that particular merger. I think there were suggestions, I think, that the ACCC wasn't given accurate information about various issues and agreed to the merger. There was a very elaborate undertaking, which was really fairly pointless in the end, because no sooner had the authorisation be granted than Armaguard saying it doesn't have the money to continue. And there's been a funny situation where sort of Armaguard initially didn't want any assistance from anybody else, and now it seems to be wanting some assistance. So what the ACCC has done is given interim authorisation to the ABA, a number of banks and the two big retailers largely, Coles and Woolies, to work together to provide financial contributions to Armaguard, which is pretty embarrassing if you ask me, having to go to your customers to ask for money to keep your business going. And it's owned by Lindsay Fox, isn't it? So he's got a few dollars to rub together. But anyway, so they're getting financial contributions from their customers to keep the business going. And the ACCC's also authorised the parties to discuss, agree and implement operational sustainability and efficiency measures across services under respective service agreements. So there's obviously risk there if they start talking about issues that could be allegations of collusion. So they've got some protection, at least on an interim basis, for those discussions. And they're going to provide financial support for time ago for up to 12 months. I personally think it's going to be a lot longer than that. Now, the next one is soft plastics. Again, a bit of a disaster, nothing to do with the ACCC, obviously. Basically, there was this red cycle collection program, which is collecting all these soft plastics and seeking to recycle them. And the company was obviously in significant financial trouble. It's just stockpiling huge amounts of soft plastics and not actually recycling it, and then it went belly up. So there's been a massive problem. There's been so much of this stockpile soft plastics in the market, and it's got to try and work out some way of dealing with it all. So the ACCC authorised the major supermarkets, and this actually involves Coles, Woolworths and Aldi, to continue collaborating to try and work out some way of recycling this massive stockpile of soft plastics. I think it was like half a dozen warehouses full of it. And effectively, they've set up these in-store collection pilot program operating in 12 Melbourne stores, 5 Coles, 5 Woolworths and 2 Aldi, and they're going to see how that works, and if it does effectively deal with the stockpile and deal with new amounts of soft plastics, then I think it'll be rolled out nationally. Now, the final thing is Dr. Williams. He's been appointed as a commissioner of the ACCC, and he's a very experienced and renowned Australian economist. He has done a huge amount of work. He's obviously from Melbourne University, Professor of Law and Economics, and he's a former executive of Frontier Economics. And it's quite interesting that in recent years, I think most of the work he's been doing is actually as an expert witness in some pretty major court cases, both for and against the ACCC. He also involved, obviously, in the Melbourne Competition Law Masters program. When it says significant contribution to scholarship, I've got to say that I don't think he's been writing very much for a few years now. I haven't seen very much coming out from him, and that's probably because he's been very busy in being an expert witness. But he's a good addition to the ACCC. Like, he's a pretty smart guy, knows economics very well. It'd just be interesting to see, I guess, where he ends up, because I guess he's been against the ACCC on a few cases, and he's been probably arguing that certain theories of harm that the ACCC have advanced aren't necessarily valid, and now he's going to have to take a much different approach. So I'm sure he'll do the job well going forward. Now, just a bit of commentary. The DG Institute is a significant case in a number of respects. I think, firstly, the big penalty against Dominic Grubisa, $1 million big penalty, and I guess probably end up having to pay that. Also, the fact that ACCC sought damages, $14.7 million, for various consumers who have been damaged by the conduct, and that's unusual. I think ACCC has been leaving a lot of these damages recovery for the class action firms. So here they've actually gone in and done that. I thought the Telstra and Optus deals with Google was funny because it was a clear breach, I reckon, of the law, and it's a serious breach, and they sort of got away by saying, sorry, we should have done it and we won't do it again, and walk away. And I think in other jurisdictions, I think somebody would have ended up in court. And I guess this is a problem with these cases. You know, these big guys probably come into the room with ACCC and say, we'll fight this for 5 years and maybe you win, but the benefits of competition won't be realised for 5 years. So your choices are fight it, delay competitive improvements in the market, or we just settle it quietly this way, not necessarily quietly, but we settle it amicably, and the competition effects will manifest immediately. So it's a difficult decision for the ACCC, and I guess there's a level of pragmatism required. The merger concerns are being raised in relation to a lot of mergers. So a lot of mergers seem to be put forward that are raising competition issues, and I just don't understand why practitioners don't necessarily alert their clients, to these problems. Some of them seem like really obvious problems to me, and sometimes you just got to say to your client that the proposed merger is a no-brainer. I remember I did that a couple of times with ACCC. Some practitioners would ring me up and say, hey, we want to do this merger. Is it got a chance, or is it a no-brainer? I just say it's a no-brainer, and I never heard from them again. So I think that's the thing. Advisors really should tell their clients the bad news up front. Merger reforms is significant, and I guess I know what happens here because I'm doing this in October. But effectively, the government is listening to industry. It doesn't want to just impose changes on business, and that's pretty welcome actually, because historically, I think under the coalition government, some of the changes are just sort of pretty well ignored any comments coming in from industry and just ran through their changes. So this is good, the way that Chalmers is consulting with industry and actually changing proposals in response to, I guess, well-reasoned arguments as to why changes are needed. Sustainability collaboration is well overdue, and it'll be interesting to see how that pans out. And I guess more interestingly, what the what the first collaborations are that seek to get authorised. There's going to be some interesting ones there. And then finally, I think the work that the National Anti-Scam Centre is doing is phenomenal. It's really improved the transparency of the various scams. It's getting alerts out there to consumers very early on so that they are able to avoid these things, describing the scams, telling you what to do to avoid it, setting up fusion cells to deal with particular egregious types of breaches. So it's been well overdue, and it's been doing tremendous work. So that's all I've had. Hopefully, if you have any questions about this presentation, feel free to drop me an email or give me a call. And I guess I'll be undertaking to do August and September and October fairly shortly and get caught up again. So thanks a lot for listening. Bye bye.